Hello, people. This is Pops at Legal Reform. You know the place, right? Legal Reform on Facebook. Legal Reformers, the beginning is a different page. It's a private page, but this one's open to the public, and I just kind of messed up making the other one public. Okay, little lady contacted me, so I was trying to tell people that with this post to come down here and share this one. For some reason, I can't share it. It usually says share a link. Here's your link. All right, this is just a copy and paste. You're going to copy all this, and then at the bottom, there's a form, a link to a form for the Judicial Inquiry Board where you file the complaint against the judge. So let me read to you what you're going to copy and paste. I'm holding you to the oath you took. I've come to claim my right to due process denied to me in the case mentioned above. Reporting misconduct is mandatory in both the Code of Judicial Conduct and the Rules of Professional Conduct, and all parties involved fail to do so, so I must do it myself. Canon 3, a judge should perform the duties of judicial office impartiality and diligently. The judicial duties of the judge take precedence over all judges' other activities. The judge's judicial activities include all the duties of the judge's office prescribed by law. In the performance of these duties, the following standards apply. B, administrative responsibilities. The judge having knowledge of a violation of these canons on the part of a judge or a violation of Rule 8.4, the Rules of Professional Conduct on the part of a lawyer shall take immediate appropriate disciplinary measures. Failure to comply. At any point, violating Canon 3 is a violation of Canon 2 and 1. Canon 3. A judge shall perform his duties of judicial office impartially and diligently. The duties of a judge take precedence over all judges' other activities. The judge's judicial duties include all other duties of the judge office prescribed by law, and the performance of these duties and the following standards apply. Adjudicative responsibilities. A judge should be faithful to the law and maintain professional competence in it. A judge should be unswayed by partisan interest, public clamor, or fear of criticism. A judge should maintain order and decorum in proceedings before the judge. A judge should be patient, dignified, courteous to litigants, jurors, witnesses, lawyers, and others whom the judge deals with in official capacity, and should require similar conduct of lawyers and staff and court officials and others subject to the judge's direction and control. A judge shall accord to every person who has legal interest in a proceeding or that person's lawyer the right to be heard according to law. A judge may make reasonable efforts consistent with the law and other courts to facilitate the ability of self-represented litigants to be fairly heard. A judge shall initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of parties concerning a pending or impeding proceeding, except that where circumstances require ex parte communications for scheduling administrative purposes, emergencies, they do not have substantiated matters or issues on the merits or authorized, provided. The judge reasonably believes that no party will gain a procedure or tactical advantage as a result of the ex parte. The judge makes provision promptly to notify that all other parties opportunity to respond. A judge may consult with court personnel whose function is to aid the judge in carrying out the judge's adjudicative responsibilities with other judges. The judge may, with the consent of parties, confer separately with the parties and their lawyers in an effort to mediate or settle matters pending before the judge. A judge may initiate or consider an ex parte communication when expressly authorized by law to do so. A judge may consult with members of a problem-solving court team when serving as a judge in a certified problem-solving court as defined in the Supreme Court problem-solving standards. A judge shall devote full time to his or her judicial. A judge shall where is it? The judge shall devote full time to his or her duties and should dispose promptly of the business of the court. A judge should abstain from public comment about pending or impeding procedures in any court and should require similar absentation on the part of court personnel subject to the judge's direction and control. This paragraph does not prohibit judges from making public statements in the course of their official duties or inform, explain to the public information the procedures of the court. I'm guessing that's supposed to be a 6. Proceeding in court should be conducted with fitting dignity, decorum, and without distraction. The taking of photographs in the courtroom during session of the court or recesses between proceedings and broadcasting or televising of court proceedings is permitted only to the extent authorized by order of the Supreme Court. The rules is not intended to prohibit local circuit courts from using security cameras or monitors in their facilities for the purpose of this rule. The use of the terms photographs, broadcasting, and televising include audio-visual transmissions or recording made by telephones, personal data assistants, laptop computers, and other wired or wireless data transmission and recording devices. A judge shall perform duties without bias or prejudice. A judge shall not, in the performance of his official duties by words or other conduct, manifest bias and prejudice, including but not limited to bias to prejudice based on race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomical status, and shall not permit staff, court officials, and others subject to the judge's direction and control to do so. Proceedings before the judge shall be conducted without any manifestation by words or conduct or prejudice based upon race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status by parties, jurors, witnesses, counsel, or others. This section does not preclude legitimate advocacy when these similar factors are issues in the proceeding. B, that's the part we're getting to. Administrative responsibilities. I put the whole canons there so that way, in case you need them for other things. A judge shall diligently discharge the judge's administrative responsibilities, maintain professional competence in judicial administration, and facilitate the performance of the administrative responsibilities of other judge and court officials. A judge should require staff, court officials, and others subject to the court's direction and control to observe the standards of fidelity of diligence that apply to the judge. Now, this is what you're using. 3A. A judge having knowledge of violation of these canons on the part of a judge or violation of Rule 8.4 of the Rules of Professional Conduct on part of a lawyer shall take or initiate appropriate disciplinary measures. B. Acts of a judge in mentoring a new judge pursuant to MR 14618 Administrative Order, February 6, 1988, as amended June 5, 2000. Discharge of disciplinary responsibilities required permitted by Canon 3 or Article 7 of the Rules of Professional Conduct, a part of a judge's judicial systems, and shall be absolutely privileged. C. Except as otherwise required by the Supreme Court rules, information pertaining to a new judge's performance, which is obtained by the mentor in the course of forming mentoring relationship, shall be confidence by the mentor. A judge should not make unnecessary appointments. A judge should exercise the power appointment basis on merit. A judge should refrain from casting a vote for appointment or reappointment of office of associate judge or judge's spouse or any other known judge to be within third degree of relationship with the judge or judge's spouses for the spouse of such a person. Disqualification. A judge shall disqualify himself or herself in a proceeding which a judge's impartiality might be reasonably questioned, including but not limited to instances where the judge's personal bias or prejudice concerning a party or party's lawyer, a personal knowledge or disputed evidentiary facts concerning the proceedings. The judge serves as a lawyer in a matter in a controversy or as lawyer within whom the judge previously practiced law, serving during such association as lawyers concerning the matter. Okay, so we're gonna get past that. The main part you want that I put the part you're using at top. All right, a judge should perform duties B3. Okay, so that's what you're using, but I just listed the whole canon. You're just using that particular part. And then after that I put the whole canon so they know that you're not playing. Okay, a judge knows that he or she individually or as a fiduciary or the judge's spouse, parent, child, wherever it's reading, economic interest in subject matter controversy to a party proceedings or has more than the means interest in that substantially affecting proceedings or okay. So I put at the bottom a judge disqualified by the terms of Section 3C may disclose on the record the bias on the judge's disqualification, may ask parties and their lawyers to be considered on the precedence of the judge whether the waive disqualification and knowing disclosure of any basis of disqualification other than personal bias, prejudice concerning a party, the party's lawyers without participation by the judge. All agree that the judge should not be disqualified, and the judge is then willing to participate. The judge may participate in the proceedings, and agreement shall be incorporated in record of the proceedings. Failure to comply. Now we're just using that one line, failure to comply, but the whole canon's there. Now, if they failure to comply with canon 3, a judge is in failure to comply with canon 1. A judge should uphold the integrity and independence of judiciary. An independent and honorable judiciary is indisputable to the justice of our society. A judge should participate in establishing, maintaining, and embracing or enforcing, and should personally observe high standards of conduct that the integrity and the independence of the judiciary may be preserved. Provisions of this code should be construed and applied to further that objective. Failure to comply. Remember, if they fail to comply with Canon 3, they fail to comply with Canon 1 and Canon 2. So let's go over Canon 2. The judge should avoid impartiality and the appearance of impropriety in all the judge's activities. A judge should respect and comply with the law, should conduct himself or herself at times in a manner that promotes public confidence in the integrity, partiality of the judiciary. B, a judge should not allow the judge's family, social, or other relationships to influence the judge's judicial conduct or judgment. A judge should not lend the prestige of a judicial office to advance a private interests of others, nor should a judge convey or permit others to convey the impression that they are in a special position to influence the judge. The judge should not testify voluntarily as a character witness. Failure to comply. Rule 8.4, misconduct. These are the rules they failed to mention or to cite for. Misconduct. A lawyer shall not violate or attempt. That was in Canon 3 at the very top, what we started with. He's supposed to, this is 8.4, misconduct. A lawyer shall not violate or attempt to violate these rules, induce another to engage in conduct, or give assistance to another's conduct when the lawyer knows that the conduct will violate these rules. Commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Engage in conduct involving dishonesty, fraud, deceit, and misrepresentation. Engage in conduct that is prejudicial to the administration of justice in relation thereof. The lawyer shall not engage in the adverse discriminatory treatment of litigants, jurors, witnesses, lawyers, and others based on race, sex, religion, national origin, disability, age, sexual orientation, socioeconomic status. Subjection does not preclude legitimate advocacy when those similar factors are issues in the proceeding. 6, state or imply the ability to influence improperly any tribunal, legislative body, government agency, or official. 7, assist the judge or judicial officer in conduct that the lawyer knows is a violation of the code of judicial conduct. 8, avoid bad faith, the repayment of education loan guaranteed by the Illinois student. We don't even need that. 9A, violate a federal, state, or local statute or ordinance that prohibits discrimination based on sex, race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status, and by conduct that reflects adversely on the lawyer's fitness as a lawyer, whether a disciplinary act reflects adversely on the lawyer's fitness as a lawyer shall be determined after consideration of all the circumstances, including the seriousness of the act, whether the lawyer knew that it was prohibited by state or ordinance, whether it was part of a pattern or prohibited conduct, and whether it was committed in connection with the lawyer's professional activities. 5. No complaint of professional misconduct is based on unlawful discriminatory pursuant to paragraph 9A, this rule may be brought until a court administrative agency of competent jurisdiction has found that the lawyer has engaged in unlawful discriminatory act and determined that the court or administrative agency has become final and enforceable and the right of judicial review of the determination has been exhausted. B, a lawyer who holds public office shall not use the office to obtain or attempt to attain a special advantage in legislative matter or a client under circumstances where a lawyer knows, reasonably should know, that such action is not in the public interest. 2, use that office to influence or attempt to influence a tribunal or act in favor of a client, or represent any client, including multiple corporation or other body, in the promotion or defeat of legislative or proposals pending before the public body for which such a lawyer is a member, of which such lawyer is employed. C, a lawyer who holds public office may accept political gain contributions permitted by law. Failure to comply and report is misconduct. Multiple counts of misconduct are as followed. Rule 1.1, competence. A lawyer shall provide competent representation to a client. Competent representation requires a legal knowledge, skill, thoroughness, and preparation necessary for his representation. A lawyer shall not represent the client in a legal matter in which the lawyer knows or reasonably should know that the lawyer is not competent to provide representation without the association of another lawyer who is competent to provide such representation. C, after accepting employment on behalf of a client, a lawyer shall not thereafter delegate to another lawyer in the lawyer's firm the responsibility of performing and completing that employment without the client's consent. Failure to comply. 1.2, scope of representation. A lawyer shall abide by the client's decisions concerning the objectives of representation subject to paragraph C, D, and E, and shall consult with the client as to the means by which they are to be pursued. A lawyer shall abide by the client's decision whether to accept an offer or of settlement of the matter. In a criminal case, the lawyer shall abide by the client's decision after disclosure by the lawyer as to a plea to be entered, whether to waive jury trial or whether the client will testify. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. C, a lawyer may limit the objectives of representation of the client consents after disclosure. D, a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but the lawyer may discuss the legal consequences of the proposed course of conduct with the client and may counsel or assist a client to make good faith efforts to determine the validity, scope, meaning of application of the law. E, a lawyer shall not participate, presenting, or thereafter to present criminal charges or professional disciplinary actions to obtain an advantage in a civil matter. F, in representation of a lawyer shall not 1, file suit, assert a position, conduct a defense, delay in trial, or take other action on behalf of the client where the lawyer knows reasonably should know that such action would severe sever merely to harass, to serve merely to harass or maliciously injure another. Advance a claim to defense the lawyer knows is unwarranted under existing law, except that the lawyer may advance such a claim or defense. It can be supported in good faith argument for an extension, modification, or reversal of existing law. 3. Failure to disclose that which the lawyer is required by law to reveal. G. A lawyer who knows a client has, in the course of representation, perpetrated a fraud upon a person or tribunal shall promptly call upon the client to recidify the same, and the client refuses or is unable to do so, the lawyer shall reveal the fraud to the affected person or the tribunal, except when information is protected as a privileged communication. A lawyer who knows that a person other than the client has perpetrated a fraud upon a tribunal shall promptly reveal that fraud to the tribunal. When a lawyer knows a client expects assistance not permitted by the rules or other law, the lawyer shall consult with the client regarding the relevant limitations on the lawyer's conduct. Failure to comply. Diligence rule 1.3. Diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. Failure to comply. Rule 1.4. Communication. A lawyer shall keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information. B. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Failure to comply. Rule 1.6. Confidentiality of information, except when required under Rule 1.6b or permitted under 1.6c. A lawyer shall not, during or after termination of a professional relationship with the client, use or reveal confidence secret to the client known to the lawyer unless the client consents to disclosure. B. A lawyer shall reveal information about a client to the extent it appears necessary to prevent the client from committing an act that will result in death or serious bodily harm. C. A lawyer may use or reveal 1. Confidence or secrets when permitted under these rules required by law or court order. 2. The intention of a client to commit a crime in circumstances other than those enumerated in Rule 1.6b or 3. Confidence of secrets necessary to establish or collect the lawyer's fees to defend the lawyer or the lawyer's employers or associated against accusations of wrongful conduct. D. The relationship or trained intervener and a lawyer, a judge, and a law student who seeks to receive assistance through the lawyer's assistance program shall be the same, and that the lawyer and client, for the purpose of the application of Rule 8.1 and 8.3 and Rule 1.6. Any information received by a lawyer in a formal proceeding before a trained intervener or panel or interviews, the lawyer's assistance program, Inc., or intermediary program approved by a circuit court in which non-disciplinary complaints against judges or lawyers can be referred to shall be deemed to have been received from a client for the purposes of application of Rule 1.6, 8.1, and 8.3. Failure to comply. Advisor 2.1. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, the lawyer may refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Failure to comply. Meritorious claims and contentions. Rule 3.1. A lawyer shall not bring or defend proceedings or assert issues therein unless there is a basis for doing so that it is not frivolous, which includes good faith argument for an extension, modification, or reversal of existing law. A lawyer and the defendant in the criminal proceedings or respondent in the proceedings that could result in incarceration may nevertheless so defend the proceedings as to require that every element of the case be established. Failure to comply. Rule 3.2, expediting litigation. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. Failure to comply. Conduct before a tribunal. In appearing in a professional capacity before a tribunal, a lawyer shall not: 1. Make a statement or material fact of law in a tribunal which lawyer knows or reasonably should know is false. 2. Fail to disclose to a tribunal material fact known to the lawyer when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. 3. Fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. 4. Offer evidence that a lawyer knows to be false. If a lawyer has offered material evidence and comes to know that of its falsity, the lawyer shall take reasonable remedial measures. 5. Participate in the creation or preservation of evidence when the lawyer knows or reasonably should know the evidence is false. 6. Conceal or assist the client in conduct that the lawyer knows to be illegal or fraudulent. 7. Engage in other illegal conduct or conduct in violation of these rules. 8. Fail to disclose the identities of the clients represented and persons who employed the lawyer unless such information is privileged or irrelevant. 9. Intentionally degrade a witness or other persons by stating or alluring to personal facts concerning a person which are not relevant to the case. 10. In a trial, allude to any other matters that the lawyer does not reasonably believe is relevant or that which is supported by admissible evidence. Assert personal knowledge or facts in an issue when testifying as a witness, or state a personal opinion as to the justice of a cause. The credibility of witness, the culpability of civil litigant, or the guilt or innocence of the accused. But a lawyer may argue on analysis of evidence for any position or conclusion which respect to matter stated herein. 11. Refuse to accede to responsible requests of opposing counsel that does not prejudice the rights of the client. Fail to use reasonable efforts to restrain and prevent clients from doing those things that the lawyer ought not to do. 3. Suppress any evidence that the lawyer or the client has a legal obligation to reveal or produce. 14. Advise or cause a person to become unavailable as a witness by leaving the jurisdiction and making secret their whereabouts within the jurisdiction. Or 15. Pay or offer to pay or requires in the payment of compensation to a witness contingent upon the content of the witness testimony, the outcome of the case. But a lawyer may advance, guarantee, or acquiescence in the payment of expenses reasonably incurred attending or testify, or a reasonable fee for the professional services of an expert witness. See, the duties stated in paragraph A are continuing duties and apply, and even if compliance requires disclosure and information otherwise protected by Rule 1.6. C. A lawyer may refuse to offer evidence that the lawyer reasonably believes is false. In ex parte proceedings, a lawyer shall inform the tribunal of all material facts known to the lawyer, which will enable the tribunal to make informed decision whether or not the facts are adverse. Failure to comply. Rule 3.4, fairness to the opposing counsel. A lawyer shall not: 1. Unlawfully obstruct another person's access to evidence, or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do such any act. 2. Falsify evidence, counsel or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. 3. Request a person other than the client to refrain from voluntarily giving relevant information to another party unless: A. A person is a relative or employee or other agents of the client, and B, the lawyer reasonably believes that the person's interest will not be adversely affected by refraining from giving such information. Failure to comply. 3.5. Impartiality and decorum of the tribunal. Before the trial case, a lawyer connected therein shall not communicate with or cause another to communicate with anyone the lawyer knows to be a member of the veneer or which the jury will be selected for the trial of the case. B. During the trial of the case, 1. A lawyer connected therein shall not communicate with, cause another to communicate with jurors. 2. A lawyer who is connected, therefore, shall not communicate or cause another to communicate with a juror concerning the case. C. Notwithstanding Rule 3.5, B. A lawyer may communicate with members of a venue or jury in the course of official proceedings. D. After discharge of the jury from further consideration or a case which a lawyer was connected, the lawyer shall not ask questions or make comments to a juror until the of which such juror is a member has been discharged. Nor shall the lawyer thereafter ask questions or make comments to a member of the veneer that are calculated merely to harass or embarrass the juror or to influence such juror's action in any future service. E. A lawyer shall not conduct or cause another to conduct by financial support or otherwise a fictitious or harassing investigation of members or veneer of a jury. All restrictions imposed by Rule 3.5 also apply to communication with or investigations of family members or the veneer of jury. G. A lawyer shall reveal promptly to the court the lawyer's knowledge of improper conduct by the member of a veneer or jury or by another towards such person or member of such person's family. The lawyer shall not give or lend anything of value to a judge, official, employee, or tribunal except for those gifts or loans which the judge or a member of the judge's family may receive under Rule 65C4 of the Code of Judicial Conduct, and except that the lawyer may make a gift, bequest, loan, or campaign contribution to the judge, to the judge that the judge is permitted to accept under the Code of Judicial Conduct, provided no campaign contributions to judge or candidate for judicial office may be made other than by the means of a check, draft, or other instrument payable or to the order of the entity which the lawyer responsible leads to be political committee supporting such a judge candidate, provide there further. However, the provision of volunteer services by a lawyer to a political committee shall not be deemed to violate this rule. I. In adversary proceedings, a lawyer shall not communicate or cause another to communicate as to the merits of the cause which a judge or official before the proceedings is pending, except 1. In the course of official proceedings in the case, 2. In writing, if the lawyer promptly delivers a copy of the writing to opposing counsel and to the adverse party if such is not represented by a lawyer. 3. Orally upon adequate notice or to opposing counsel or to the adverse party if such a party is not represented by a lawyer or as otherwise authored by law. Failure to comply. Trial publicity. A lawyer who's participating, Rule 3.6, trial publicity. A lawyer who is participating or has participated in investigation, litigation, the matter shall not make an extrajudicial statement that a reasonable person would expect to be decimated by the means of public communication if the lawyer knows or reasonably should know that will pose a serious and imminent threat to the fairness of adjudicative proceedings. B. There are certain subjects which would pose serious and imminent threat to fairness of a proceeding, particularly when they refer to a civil matter triable by a jury or a criminal case. These subjects relate to 1. The character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, or the identity of a witness, or the unexpected testimony of a party witness. In a criminal case, the possibility of a plea or guilty of the defense or existence of contents and any confession, admission, or statement given by the defendant or suspect or that person's failure to make a statement. 3. The performance or results of any examination or test, of failure of a person to submit an examination or test, or the nature of physical evidence expected or presented. 4. Any opinion to the guilt or innocence of a defendant or subject in a criminal case. 5. Information the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial. Or 6. The fact that the defendant has been charged with a crime unless there is included therein statement complaining that the charge is merely an accusation and the defendant is presumed innocent unless proven guilty. C. Notwithstanding paragraph A, a lawyer may state 1. The claim, offense, defense involved, and except when prohibited by law, the identity of the persons involved. 2. Information contained in the public record. 3. An investigation of matter that is in progress. 4. The scheduling or result of any steps in litigation. 5. Request for assistance of obtaining evidence and information necessary thereto. 6. A warning of danger concerning behavior of a person involved where there is reason to believe that there exists the likelihood of substantiated harm to an individual or to the public interest. 7. In a criminal case, in addition to subparagraphs 1 through 8 through 6, I, the identity, residence, occupation, and family status of the accused. Well, that's 1. 2. If the accused has not been apprehended, information necessary to aid in the apprehension of that person. 3. The fact, time, and place of arrest. And 4. The identity of investigating and arresting officers or agencies and the length of the investigation. D. Notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial, undue prejudicial effect or recent publicity not limited by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate and the recent adverse publicity and recent adverse publicity. E. No lawyer in a firm or government agency or otherwise associated with the lawyer subject to paragraph A shall make a statement prohibited by paragraph A. Failure to comply. Rule 3.0, 3.8, special rules of prosecutor. Duty of a public prosecutor or other government lawyer is to seek justice, not merely to convict. B. A public prosecutor or other government lawyer shall not institute or cause to be instituted criminal charges when such prosecutor or lawyer knows or reasonably should know that the charges are not supported by probable cause. C. A public prosecutor or other government lawyer in criminal litigation shall make timely disclosure to counsel for the defendant or to the defendant if the defendant is not represented by a lawyer of existence of evidence known to the prosecutor or other government lawyer that tends to negate the guilt of the accused or mitigate the degree of the offense. C. In addition to his or her obligations under 3.6, a public prosecutor or other government lawyers in a criminal investigation shall exercise reasonable care and prevent investigations, law enforcement personnel, employees, or other persons associated with the prosecutor in a criminal case for making extrajudicial statements that the public prosecutor or other government lawyer would be forbidden from making under Rule 3.5. The prosecutor in a criminal case shall refrain from making extrajudicial comments that would pose a serious imminent threat and highlighting public condemnation of the accused, except for statements that are necessary to inform the public the nature of the extent of the prosecutor's action that serve as a legitimate law enforcement purpose. Failure to comply. Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not make a statement of material fact or law to a third person which statement the lawyer knows or reasonably should know is false. B. Failure to disclose a material fact to a third party when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by Rule 1.6, failure to comply. Rule 5.1, responsibilities of a partner or supervisor or a lawyer. Each partner in a law firm shall make reasonable efforts to ensure that the firm has in effect measures in giving reasonable assurance that conduct of all lawyers in the firm conforms to these rules. B, each lawyer having direct supervisory authority over another shall make reasonable efforts to ensure that other lawyers' conduct conforms to these rules. C, a lawyer shall be responsible for another lawyer's violation of these rules if the lawyer orders or, with knowledge of the specific conduct, ratifies the conduct involvement. Or 2, the lawyer is a partner of a law firm which the other lawyer practices in direct supervisory authority over the other lawyer and knows the conduct at a time when its consequences can be avoided by or mitigated but fails to make reasonable remedy action. Failure to comply. 5.2, responsibility of a subordinate lawyer. A lawyer is bound by these rules, notwithstanding that the lawyer acted in the direction of another person. B, a subordinate lawyer does not violate these rules if a lawyer acts in accordance with a supervisory lawyer's reasonable resolution or an arguable question of professional duty. Failure to comply. 5.3, responsibilities regarding non-lawyers' assistance with respect to non-lawyer employer retained by associated with the lawyers. A lawyer in a law firm, each partner shall make reasonable efforts to ensure the firm has in effect measures giving reasonable assurance that the non-lawyer's conduct is compatible with the professional obligations of a lawyer and the firm. B, each lawyer having direct supervisory authority over non-lawyers shall make reasonable efforts to ensure that the non-lawyer's conduct is compatible with professional obligations of the lawyer. C, a lawyer shall make reasonable for a non-lawyer's conduct that would be a violation of these rules and engaged in by a lawyer. 1, a lawyer orders or with knowledge of specific conduct ratifies the conduct involved. Or 2, the lawyer is a partner of a firm and has direct supervisory authority over a non-lawyer and knows that the non-lawyer's conduct at the time when its consequences can be avoided or mitigated, but has to take reasonable remedial action. Failure to comply. Rule 8.3, reporting professional misconduct. A lawyer possessing knowledge not otherwise protected as confidence by these rules or by law that another lawyer has committed a violation of rules 8.4a3 or a4 shall report knowledge to a tribunal or other authority empowered to investigate or act upon such violation. B, a lawyer possessing knowledge that not otherwise protected as confidence by the rules of the law that a judge has committed a violation of the code of judicial conduct, which raises a question as to the judge's fitness for office, shall inform the appropriate authority. C, upon proper request of the tribunal other than authority empowered to investigate or act upon the conduct of the lawyer, judges, lawyers processing information not otherwise protected as a confidence by these rules or law concerning another lawyer or a judge shall reveal fully such information. D, a lawyer who has been disciplined as a result of a lawyer disciplinary action brought before the body other than the Illinois Attorney Registration Disciplinary Commission shall report the fact to the commission. Failure to comply. 8.4, misconduct. A lawyer shall not violate or attempt to violate these rules. 2, induce another to engage in conduct or give assistance to another's conduct when the lawyer knows that the conduct will violate these rules. 3, commit a crime or act adversely on the lawyer's honesty. Commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. 4, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. 5, engage in conduct that is prejudicial to the administration of justice and in relation thereto. A lawyer shall not engage and adverse discriminatory treatment of litigants, jurors, witnesses, lawyers, and other based on race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status. This objection does not preclude legitimate advocacy when there are similar factors are, are issues in the proceeding. C. State or imply the ability to influence improperly any tribunal, legislative body, government agency, or official. 7. Assist a judge or judicial officer in the conduct if the lawyer knows is in violation of the Code of Judicial Conduct. 8. Avoid in bad faith repayment of education loan. We don't care about that one. 9A. Violate a federal, state, or local statute or ordinance prohibits discrimination based on race, sex, religion, national origin, disability, age, orientation, socioeconomic status of a conduct that reflects adversely to the lawyer's fitness as a lawyer, whether a discriminatory act that reflects adversely on the lawyer's fitness as a lawyer shall be determined after consideration of all circumstances, including the seriousness of the act, whether the lawyer knew that it was prohibited by statute or ordinance. 3, whether it was part of a pattern or prohibited conduct, and 4, whether it was coordinated in connection with the lawyer's professional activities. 5, no complaint of professional misconduct based on unlawful discrimination act pursuant to paragraph 9A of this rule may be brought until a court or administrative agency of competent jurisdiction has found a lawyer has encouraged in or unlawful discriminatory act and is determined in a sort of administrative agency has become final and enforceable, and the right of judicial review to determine has been exhausted. B. A lawyer who holds public office shall not use that office to obtain or attempt to obtain a special advantage in a legislative matter for the client under circumstances that a lawyer knows or reasonably should know that all such action is not in the public interest. 2. Use that office to influence or attempt to influence a tribunal to act in favor of a client. Or 3. Represent any client, including multiple corporations or other public body, in the promotion or defeat of legislative or other proposals pending before a public body of which the lawyer is a member, of which or by which such lawyer is employed. C. A lawyer who holds public office may accept political campaign contributions permitted by law. Failure to comply. Okay, this is the part I wrote in. As it stands, the judge was supposed to report misconduct, as were the counsel for the defense, as well as opposing party, and reporting misconduct is mandatory. It is easy to conclude that it's easy to conclude that they were all in this together in a complete denial of my right to due process. As it was done to me, I believe it was commonplace. It was common course taken in every case that the judge presided over, which left them in contempt of the very court they preside over. So my demands must be met as follows. May I reiterate, failure to comply with the rules of professional conduct is a deliberate denial of due process and only furtherance abuse of power. The Fifth Amendment provides that citizens not be subject to criminal prosecution and punishment without due process. Citizens may not be tried on the same set of facts twice and protected from self-incrimination, the right to remain silent. The amendment also establishes the power of eminent domain, assuming that private property is not seized for public use without just compensation. Clearly, the Sixth Amendment assures the right to a speedy trial by a jury of one's peers to be informed of crimes of which they are charged and to confront the witnesses brought by the government. The amendment also provides the accused the right to compel testimony from these witnesses and to legal representation. The assertion of a quick and speedy trial starts at the point of arrest in a criminal case, or in a civil case, the point of filing limits that to 120 days, something often taken advantage of. In the preamble, says a lawyer's responsibility states, and I quote, 12, the legal profession's relative autonomy carries with it special responsibilities. Some government profession has a responsibility to ensure that regulations are conceived in the public interest and not furtherance of a patriarchal or self-interest concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should aid in securing their observance by other lawyers. Neglect of these responsibilities compromise the independence of the profession and the public interest which it serves. 13. Lawyers play a vital role in the preservation of society. The fulfillment of this role requires an understanding by a lawyer and their relationship to the legal system. The rules of professional conduct, when properly applied, serve to define that relationship. The rules did not apply in this case and didn't happen, and I quote paragraph 2, as a representative of clients, a lawyer performs various functions. As an advisor, a lawyer provides a client with informed understanding of the client's rights and obligations and explains their practical implications. As an advocate, a lawyer zealously asserts the client's position under the rules of the adversary system. As a negotiator, a lawyer seeks results advantageous to the client but consistent with requirements and honest dealing with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them to the client or to others. The client's right requires reasonable knowledge to make an informed decision, and keeping said requirement from in keeping said requirement from any client is a complete denial of due process. If this conceivably happened to me, which it did, I believe it necessary to see how many others were victims of the perpetrators of the above said fraudulent and frivolous action taken against me. I reiterate that any said violation of the rules of professional conduct is a violation of my right to due process, which would make any case fraudulent and frivolous. This is clearly malicious prosecution, and for what purpose? Financial gain, political aspiration, simple bias, and prejudice prejudice for statistical purposes, a high rate of conviction, or a combination of each. Having no knowledge or understanding of what went on in the court, not to mention no access to discovery, is not reasonable knowledge. I think the above alone proves that denial of due process then include the lack of knowledge that the ARD existed and why. The Eighth Amendment prohibits excessive bail, excessive fines, and cruel and unusual punishment. I believe keeping any client from reasonable knowledge in any shape or form from any legal remedy to obtain justice is a violation of due process. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. I understand there are no laws or rules for criminal action to be taken against the legal system and its entities for blatant disregard of due process. As of now, you are required to change that. Accountability is required to maintain my trust, the public trust. That is your responsibility, and the neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. And having special responsibility for the quality of justice, you are required to zealously assert the public interest which it serves, demonstrate respect for the legal system and for those you serve, the public. To deny the people, we the people, any single one of us due process can be said to be cruel and unusual punishment. The 10th Amendment assigns all powers not delegated to the United States or prohibited to the states, to either of the states, to the people. The people require you to take action, to defy the rules of professional conduct, the code of judicial conduct, to defy due process, as it is to defy the public trust, a sacred trust, and must be dealt with accordingly. Betraying the public trust is seditious, treasonous, and should have consequences and repercussions. Prosecution is in order. When entrusted with a sacred trust, the trust of we the people, One must be held to a higher standard when defying that trust. There are no excuses. There is no defense, for every lawyer is responsible for the observance of the rules of professional conduct, as every judge is responsible for the observance of the code of judicial conduct. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. Article 7, Illinois is a professional conduct preamble. Lawyer's responsibilities. 1. A lawyer, as a member of the legal profession, is a representative of a client, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. Thus far, there's a lack of quality which is adverse to justice. 6. As a public citizen, the lawyer shall seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered to the legal profession. As a member of the legal profession, a lawyer should cultivate knowledge of the law beyond its use for clients employed in knowledge to reform of the law and work to strengthen legal education. In addition, a lawyer should further the public understanding and of the confidence in the rule of law and the justice system, because the legal institutions and the Constitution, democracy, depend on popular participation support to maintain their authority. We, the people, require the forum necessary to incarcerate those that once held the public trust. The penalties must be severe and swift and beyond compared to any standard set forth to we, the people. One cannot assert qualified immunity, statute of limitations, non-disclosure agreements, as the preamble requires. A legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not in furtherance of the patriarchal or self-interest concerns of the bar. Every lawyer is responsible for the observance of the rules of professional conduct. The lawyer should aid in securing the observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. To not proceed with criminal prosecution against those that perpetrated fraud in a court of law by defying due process is not in the public interest and is furtherance of patriarchal and self-interest concerns of the bar. We, the people, have spoken. The public interest must prevail. No one above the law, lawyers, judges, politicians, police, the president, and none below the law like me. When I say me, I mean we, as in we, the people. I am many, we are one. We are the defenders of the Constitution. In a nation of laws, we stand by rule of law and demand you do your duty. Stand by your oath and defend the Constitution as willingly, open-heartedly as we do. I came here where freedom is being defended, to serve it and to die for it. General Casimir Pulaski to General George Washington, 1777. Without due process, there is no life, liberty, or pursuit of happiness. You cannot divide the very principles this great nation was founded upon. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. Thomas Jefferson, the Declaration of Independence, Second Continental Congress, Philadelphia, Pennsylvania, 1776. We hold these truths to be self-evident, that all men and women are created equal. Elizabeth Cady Stanton, the Declaration of Rights and Sentiments, Women's Rights Convention, Seneca Falls, New York, 1848. fourscore and 7 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. President Abraham Lincoln, Gettysburg Address, Gettysburg Battlefield, Pennsylvania, 1863. I have a dream that one day this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident, that all men are created equal. Reverend Martin Luther King Jr., The March on Washington for Jobs and Freedom, Washington, D.C., 1963. Okay, people, little notation here telling you there's a PDF right here. You click on that and you get the form to file with the Judicial Inquiry Board. You can file electronically. You can deliver it in person. The address is there. You can fax it. Okay. This is all you need to say. Remember, your story is a key that can unlock someone else's prison. I've just told mine. Now it's time for you to tell yours. Thank you. Pop signing off.